get this started. Okay, guys, so like we said last week, that this week we'd be carrying on with the tutorial question, which I needed us to discuss, but because I'd uploaded the information literally the day before, I wouldn't expect you guys to, wouldn't be fair. All right, so let's have a look then. This is regarding retrieval of evidence, and it does come down to that question of the right against self-incrimination. And two cases dealt with this question of retrieval of physical evidence. So away from DNA samples, moving away from the question of DNA samples merely. So like blood samples or saliva swabs, even moving away from fingerprints. What it was looking at, and these two cases were very, very similar in the sense that both of the accused persons and both of the persons who were contesting various rights, and you'll be able to tell me what those rights were, had bullets lodged in them, in their bodies, from having been in pursuit and in an altercation with the police in two different factual scenarios. Now, what the interesting thing is that one decision came from the Cape, and a short while later, another decision came out from Natal, from Durban. And both courts came to different conclusions regarding whether or not the Criminal Procedure Act, looking at Section 27, Section 37, etc. of the Criminal Procedure Act, allowed for this forced non-consensual removal of physical evidence. Okay, and the key questions, the 2 or 3 or 4 questions as they've been divided that you need to consider is there a difference between the removal of a blood sample and the removal of physical evidence? So that's the first thing. Secondly, does the forced removal of physical evidence, for example, a bullet, from the body of the accused violate against the right against self-incrimination? And those two tie up. And the second part is, what does such an order made by the court, either for or against removal, say about the crime control and due process models? And that question takes us back to our very first lecture session regarding these two systems. All right, so how did you deal with this? I think let's start with discussion of the cases. So who wants to have a go? Anyone?
Miss B, I'm just trying to gather my notes here.
Okay.
I was on another topic.
Okay, you would have had ample opportunity now to have looked at the cases, to read the articles at least, because even if you haven't looked at the cases, I've told you can work smart, not hard, and look at the articles. The articles, the readings were put onto Moodle for you. So you ought to be able to discuss these cases and even address those questions, because these questions have been addressed to a large extent in those articles. And I want us to follow a logical sequence, to work out how to answer these types of questions. Is there a difference between the removal of a blood sample and the removal of physical evidence? Does the forced removal of physical evidence from the body of an accused violate against the right um, against self-incrimination? Okay, go ahead, Michael.
Ms. B, I don't, my notes on my USB and I can't find it, but I think from what I read on the case of, is it Cabo or something like that there? In terms of that case, I read that the court found that the act of removing blood samples, it, it does not, it didn't provide for the removal, for the surgical removal of an object or some sort from the body of a person in the course of criminal investigation. So I think
the first case said yes you can, and the second case said no you can't.
Yeah, that's what I was trying to say.
Yeah, so
sorry,
the question is why? And what were the arguments made by each of these accused persons? You'll see essentially the arguments are the same. And how can the court then, applying the same constitution, the one constitution that we have, come to such different conclusions?
Ms. B, is it because that surgical removal or intervention whereby you're taking something physically from a person, it infringes that person's rights in terms of dignity and physical and bodily integrity? Does that work into the discussion?
It does to an extent, but you'd have to have read the articles to be able to make that connection meaningfully.
Yeah, I understand that. Yeah. I'm just trying to spitball because I can't find the notes. So
yeah, look, there were various arguments raised in both. Okay, right to bodily and physical integrity was one. But looking at this part of the question, this part of the question here, is essentially what we need to be considering. Is the removal of physical evidence, something lodged, is that testamentary or is it non-testamentary? Because when you look at the articles and the notes that discuss what is a testamentary utterance and what actually does the right against self-incrimination mean, that is a very, very important question. And yes, the questions about the various constitutional rights does come in, right? There were also questions about, and the courts made reference or argument was made regarding how the same sort of issue was dealt with in foreign cases in the States. And one of the questions that arose, well, and this you'll see from reading the case, when you do get to read the case, that one of the arguments by one of the accused persons was, well, if the bullet lodged is not doing me any harm, in the sense that I'm healthy, but for the fact that I've got a bullet wound. But if you go in and perform an operation, there's a chance that my life will be placed in danger due to that operation. And so it then becomes a balancing exercise for the court. The balancing exercise being communities' rights to justice and the need to police and investigate and prosecute. And the only way to do that is with evidence versus an individual's rights. And if you look at both decisions together, ultimately what comes out is, well, how do you balance that? How do you balance that? The need for justice. You also want to avoid a scenario where criminals, let's call them criminals in this case or cases, can rely on these constitutional rights and not have this evidence that is now lodged in them be used or retrieved and used against them. So it's a delicate balancing exercise. And in the one case, they said, well, there's no other evidence to tie this accused person even to the scene of the crime. So this is what we need to do in consideration of the fact that the removal of the bullet will not be detrimental to his health, right? The risks are low. And see what the same thought process led to a differing conclusion in the Xaba case. Now, no decision necessarily is incorrect. I think this is a good example of that, where I would have to say that the decision in Xaka was correct and the decision in Xaba was correct. But you'd know that or be able to work that out having read the cases and the articles, and based on what the courts made their decision. What is important that comes out from both cases is that in order to conduct this type of search and seizure, because this is what it is, Section 27, search and seizure, and the lawfulness of it will have to be determined on a case-by-case basis. So it's no blanket rule or blanket provision. Another argument that came out in the Xaba decision was that where the Criminal Procedure Act specifically legislates for blood samples, it hasn't specifically legislated for the retrieval of other physical evidence like bullets or shrapnel or something like that. There's also no clear definition of what search means. There's when the place or places that can be searched are referred to, they talk about places and premises. And I don't know that a human body fits that description, even a dictionary description. So it's very, very important that you have a look at that so that you can make get a meaningful understanding of what's going on here. And it's unfortunate that you're not prepared to discuss this. Otherwise, we could certainly have extrapolated that much further. All right, any questions before we move on? Michael, go ahead.
Ms. B, could you maybe explain this a bit further? Even though we've I don't know who's been through the readings or not, but how would we balance the two interests? So one, the ascertainment of bodily features and the rights of the person that's been ascertained from.
That's your application of Section 36 of the Constitution. Isn't that Section 36 of the Constitution?
Yeah, the limitations clause.
No easy task, and it's certainly not easy for me to say to you without an actual scenario, because you must look at both the cases and see how the court looked at Section 36 in both cases and came up with different conclusions. A way to ask about Section 36 and balancing, is, can the same end result be achieved through less restrictive or less harmful or less dangerous or less intrusive means? That's a way.
What
You're going to take the whole of section.
what would you propose, or I was going to ask what would you propose are less restrictive or invasive means?
Well, I think in today's day and age, time, for example, there have been, so compared from 2004, which was the last decision, right? 2002 was Gaka,
The earlier one.
and 2004 was Baba. But there have been considerable developments in X-ray technology, and MRI and scans and that sort of thing. It's very possible that sophisticated enough X-ray could be taken of a bullet and be able to forensically match it to a particular gun or a chamber without physically, a physical invasion. But that's science. That's science. It also depends on what sort of technology is available in the jurisdiction in which you are operating. It does. The major question, though, is, which you will have to address, is even if it's allowed, is it testamentary evidence? In other words, is it a violation against your right to self-incrimination? The removal of this sort of evidence.
Yes, I agree, must be. Yeah.
That's what you're going to have to consider.
As the word that you like to use, it's a conundrum. A conundrum or something like
It
that.
is quite a conundrum.
Yeah.
It is quite a conundrum. All right, and you saw that there are two high courts, both coming to different conclusions. Okay, so this takes us forward. So search and seizure takes us forward from that last set of slides, which was interrogation and ascertainment of bodily features, and builds on from that tutorial about, well, what can be searched for and what can be seized, right? And where can you search for things? Yeah. So search and seizure, you'll understand to be searching for evidence like the drugs, the murder weapon, the stolen vehicle, whatever the case may be, right? And having gone through the slides and the audio, you've picked up that search and seizure also, as it's contained in the Criminal Procedure Act, allows for police to search premises for people. In other words, looking for suspects or looking for people who they can ask questions of, right? But this is, again, is a great power. It's something that needs to be treated very carefully, and you need to tread lightly and cautiously because of the type of rights that search and seizure generally violate against. I mean, you wouldn't take it kindly if in a lecture venue I just walk up to you and start opening your pencil case and start looking for things. Would you be happy I did that? Probably not. I would hope not. If I did that, what would you say? Why am I acting unreasonably or unlawfully? Because I would have violated against your right to privacy. I would violate against your freedom and security of the person if I came and physically touched you, right? And searched through your things and pilfered through your things. And now police officers have the power to conduct searches and seizures, and also pay attention to those bits in the notes and the slides that talk about, as we spoke about previously, private citizens' arrests, and focus now on whether private citizens can conduct things like searches and seizures. So what can be searched for and seized? Okay, the nature of the type of thing. Essentially, it is what things and where can they be seized, right? It's anyone who, so the Criminal Procedure Act allows search and seizure only if the purpose is to find a particular person or to seize an article which falls into a particular category. As we saw with arrests, must have a particular purpose. This search and potential seizure must also have a particular purpose. The purpose would be to look for someone who this person conducting the search has reasonable grounds to believe was concerned in the commission of an offense or suspected commission of an offense, or someone who would give evidence, right? So someone who's a witness, or even items that were used, could be used, or even stolen items, right? So there is, of course, the exception regarding privileged documents and privileged statements. Again, over and over and over again, when we deal with the investigation part of criminal procedure and the exercise here on this part of the process model, much is relied upon. The investigation, all of it pretty much lands in the hands of police officers, right? And often in all of these sections that we've dealt with, we come across the phrase reasonably believes, reasonably suspects, has reasonable grounds. We've already discussed at length what we mean, how do we understand what is reasonable and what is reasonable for a police officer, okay? So have a look at that as well. Now, as with arrests, searches and seizures must also be done, first prize must also be done with a warrant. But as we discussed with, arrests, circumstances may be such that it would be imprudent, in other words, not practical, or would be a travesty and a failure in the system of justice if a police officer was to say, hold on, can you just wait here? I need to search you, but I don't have a warrant. So you just wait here. I'm going to go get a warrant and I'll be right back. Okay. So first prize is that search and seizures happen with warrants. And you can look and read in the slides, in your notes, listen to the audio, what is required for a search warrant to be granted, right? And that one, the wording must be done in a way that is not vague, because if it is vague, the search warrant itself can be invalid. And what does that mean for what you may have searched for and retrieved? It means that that is unlawfully obtained and therefore impermissible and not possible to be submitted as evidence in a trial. So it's also important that we understand what the importance of having a search warrant worded properly, executed properly, is about. Search warrants can also, searches, not search warrants, searches can also be conducted without warrants, as we saw in the same way that you get arrests with warrants and arrests without warrants, okay? And again, the lawfulness of that search will be determined ex post facto, because in a trial, it will come out, the defense will say, no, we object to this evidence as having been unlawfully obtained. It was done without a warrant, and there was no reasonable grounds for believing, etc., etc., etc. And that will come clear to you when you look at this through the slides. Okay, look also at search and seizures at a roadblock or a checkpoint. Basically, the police get a permit or permission to set up a roadblock, but they don't get a search warrant for each individual vehicle that is there, because it's impossible to know who's going to be driving on a particular road. So it's somewhat of a blanket search warrant, empowering the police to check particular vehicles as they pass the checkpoint. Again, reasonableness for stopping particular vehicles, etc., comes in. So have a look at that. This is important. Powers of occupiers of premises. Now, what does this mean? That means that if I own a property, or I'm landlord of a property, or I've got people staying on my premises, what powers do I, as owner, occupier, or even a roommate of a particular place, have to conduct search and seizures of other rooms, properties, or people living on the property? It can be done. But again, look at what the rules and the requirements are as far as reasonableness, reasonable suspicion, if no police official is available. Okay, any person who lawfully occupies, who reasonably suspects, and it goes back to that there are things like drugs, weapons, illicit activities, illicit drugs, etc. Okay, so searches for the purpose of effecting an arrest. That means I need to search a place because I believe that the suspect ran into this building, or I believe that Suhaifa Bamji lives here and I have a warrant for her arrest, right? You get a search warrant to search a premises to find the person that you are attempting to arrest. And yeah, can you search a person once they've been arrested? Yes. Uh, have a look at the notes and slide on that, right? Use of force again. This is where we were talking about the previous tutorial as well, where the court in Aba and Gaka. Now remember there, the key things that you were meant to be discussing in that tutorial question was whether that evidence, the bullet, was a right against the violation, self-incrimination. Other aspects that the judgments spoke about was this section 27, use of force to retrieve that evidence, right? And that's where we see section 27. In this context, though, of search warrants, and we'll confine our discussion to search warrants as it relates to buildings and premises. Section 27 is what we call colloquially the no-knock clause. Now, previously, as you would have seen with section 26, when a police officer wants to gain access to a premises, he must audibly announce, say, I am police officer X, I'm here to arrest Joe, da 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 da, or I'm here to look for da da da. So he audibly announces, gives that information, and then requires permission from the occupier to be allowed onto the premises to conduct that search. The no-knock clause, however, understands or accepts that in practicalities and practical policing and practical investigation, that might not always be the best option. In other words, to have the police officer announce why he or she is there. Because if the item is small enough, delicate enough, it could be eaten, it could be destroyed, it could be flushed, and then the thing that you are searching for is destroyed. And so section 27, and that defeats the purpose of your search in total, right? And would defeat the ends of justice. So section 27 is that what we call the no-knock clause, where you see, and in your mind you're thinking, oh, police busting down doors and breaking open windows and battering rams and that sort of thing. And essentially that is what it is. But it is important that it is also done so reasonably, because as we saw with arrests, there can be unlawful arrests, mistaken arrests. There could be also unlawful searches and seizures and mistaken searches and seizures, which means delictual and or criminal liability for the investigators, for the department, for the repairs as a result of those broken doors, broken windows. Section 29 also talks about propriety, in other words, is decency. So searches, seizures, etc. must also be done in a reasonable, decent, lawful fashion. Males must only be searched by males, females must only be searched by females. Okay, and I've just spoken to you about unlawful searches. So the tutorial question I would like us to address, which I do hope you've looked at, is this one. Joe, a police officer, forcibly opens the cellar of the accused, Wendy's house, without Wendy's consent and without a warrant to search. Joe then searches the cellar and finds a bag full of Mandrax tablets, 100 kilograms of dacha, and documents addressed to Wendy's lawyer. During the trial, Wendy argues that the search was illegal because Joe did not act upon a warrant and in accordance with the provisions of the CPA, and that Joe's evidence relating to the dependents producing substances and the documents must be excluded as evidence as it was obtained unlawfully. The prosecution argues that Joe acted lawfully and the court must allow Joe's evidence. Question 1. In light of the above scenario, critically discuss the case of Minister of Police and others versus Grace and Kunjana. In light of the constitutional validity of police power to conduct searches and seizures without a warrant. Secondly, discuss whether the arguments of Wendy or the state should be accepted by the court. Your answer must also reflect the classes of articles that are susceptible to seizure. All right, let's talk. Are you able to discuss? Anyone? I could go ahead.
I'm sure must be. So I've been somewhat through the case, and I saw that they speak about search and seizure in terms of the Drugs and Drug Trafficking Act.
Oh.
So essentially, in terms of this case, prior to the constitutional invalidity of that Section 11 of that Act, in this case, it was a police official was permitted to a police official may, if he has reasonable grounds to suspect that an offense under this act. So if Kunjana, in the case of Kunjana, if that person was suspected of having possession of illegal substance or something, he could he or she was permitted to gain entry into the premises without a warrant, and in application of the no-knock clause.
Yeah, but you'd have to, the point is that how do you prove reasonable grounds, reasonable suspicion? And was it a point of urgency where it was not prudent for the police officer to stop and go and get a search warrant and return?
Okay.
Then the next thing you have to also discuss, and that's a big part, although I've dismissed it in 2 or 3 sentences, that's actually a big part of what needs to be discussed. It goes to the nature of what has been, the second part now, the nature of what is being searched for and seized, the classes of articles. So which is protected by the privilege? Number one.
Can you please
which of the
rephrase, Ms. B?
Sorry?
Oh, I was just confused as to what you said. I was going to say, can you please rephrase a bit?
Let's look at the second question. Discuss whether the arguments of Wendy or the state should be accepted by the court. So what is Wendy's arguments? Wendy's argument is threefold. Tell me what Wendy's arguments are.
First, that that the search was illegal because the police official Joe, he did not act with the warrant.
Right. So there was no search warrant.
Yeah.
Right.
And that his evidence relating to the dependence, so relating to the possession of the drugs, the mandrax and the dacha, and the documents must be excluded as evidence because it was obtained unlawfully. She's not disputing that it was unlawful to be in possession of them, but because he did not obtain it with the necessary search warrant, that evidence should not be permissible.
Right. And what is less plain, and which comes from the previous part, is that the documents are possibly susceptible to the rule regarding privileged statements and privileged documents. So you must remember to also discuss that when you're discussing documents, not just that they were seized without a warrant, but that the documents were communications between herself and her lawyer, which are protected by the privilege, which she would maintain. So that's also an exercise in being able to suss out what the arguments she would be making are. It's not always going to be made plain as saying she argues number 1, she argues number 2, and she argues number 3. But I said to you that her arguments were threefold. You picked out 2 things. The third one was the privilege nature of those documents.
Thanks, Ms. B.
All right. Does anyone have anything to offer regarding this question?
Ms. B, if you don't mind me saying, I mean, in terms of the current climates of South Africa on drugs. I'm just want to look at the arguments of the Dacha, for example. I mean, I would say personally, because there hasn't been a sufficient regulation of how much Dacha this person could have on them or not. And because of that, maybe having that 100 kgs of Dacha is within the limit, but obviously it's not. I think it's 100 grams or something you can have, or something like that.
Without that statement of how many grams. You did the assignment last semester, didn't you? Right, you did that assignment already last semester. And the Prince case talks about personal use. Personal use.
Okay.
A bag full of Mandrax, 100 kilograms of Dacha. Does that look like personal use?
I mean, the Dacha probably not. The Mandrax, it's debatable because it's not necessarily, it's vague as to how big that bag was. Maybe it was a small.
Don't look for facts that aren't there. A bag full, even if it's a handbag, but it's a handbag full of Mandrax.
Yeah.
Right, but Mandrax falls out of what is the question of personal use, because the Dacha is personal use, right? Mandrax is an illicit drug and falls into a whole other category as far as the Drug and Drugs Act is concerned.
Yeah.
Bag of Mandrax is a bag of Mandrax, regardless of how small the bag of Mandrax is, subject to de minimis, whatever. That's a trial on its own, right? Even if she just had a bag of Mandrax and forget the. But if we're talking about this, let's say Mandrax was out of the equation and it was only this question about 100 kilograms of Dacha, still comes down to whether or not that being in possession of that Dacha was a criminal offense.
I think the quantity maybe.
The quantity enough for personal use. Does it look like she's a dealer? I think
probably like she's a dealer.
A reasonable person would say she looks like she's a dealer.
Definitely.
Okay. All right. I think I don't know that there's anything much else we can say without input from the others. But please, guys, it's getting difficult to have these sessions with you when you aren't prepared to discuss the tutorial questions. It's not going to be meaningful for you, and it's ultimately that's what you need. You need a engaging session where you've cast your mind to the issues and you can explore those with me in preparation leading up to the final assessments. All right, I will see you all next week then. Thank you.